during that time, I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Sustained?
How long have you been with the sheriff's department?
Since
How long have you been a homicide detective? Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda? Do you recall again reading her Miranda rights to you on video? Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Overruled.
Okay. Do they have a Miranda cards form in the interrogation room? So you would have had that on your person?
You may.
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. Again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness.
Response. Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision, all talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that, Judge.
The right to remain silent, the right to an attorney, before and after question. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. The Miranda opinion itself says that. So what does question number 9 have anything to do with those things of the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state? Identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they weren't.
I want to finish one.
Okay.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights, and then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is this form, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old car, but still, I feel like it should be considered in your decision.
Anything else, Mr. Chair?
It's essentially the defendant's statement.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas 351, 7-3rd 197, and Owens 41, 7-3rd 352. It's not relevant as to what the questions need to be asked for the purposes of whether the waiver was given.
Do you agree, Detective, that after you read her those Miranda rights,
What is it that's been marked as defense exhibit? Any objection? Is it the form as of now, or is it the form as of 2020 when the... Any additional argument with regard to the state's relevance objection? No, I'm sorry, Mr. Gay, I wasn't specific enough. Mr. Owens, to you, any additional argument? I'm going to sustain the relevancy objection for the same reasons that were articulated previously. And Mr. Owens, you have one additional exhibit as well. Do you know what page specifically those policies are on? Is it beginning of paragraph 4, waiver of constitutional rights? I've read pages 14 and 15. 13?
13, it's the next,
Oh, there's two different sets. Is it
Split up.
composite? My apologies.
it's split up.
Got it.
Here, 28 at the bottom, T. And then it goes on to the next page. 14. And specifically 2A and 14.
Anything else?
Or the argument,
Anything further? Okay. All right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C, and that'll be received into evidence over objection as state 1. I'm sorry, defense is 1. Any further witnesses, evidence, or testimony, sir?
I'd like to call Sarah Boone.
Ms. Boone can approach the podium. She was previously sworn at the beginning. Yes, sir. Hang on, the deputy's got to move her. And you've already been sworn. Counselor, you may proceed.
And would you please state your full name? You're going to have to speak up or move the mic.
Yes.
Are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020? Was that the date of this interrogation that we're here for on this motion? Let me take you back to the morning of finding George Torres in the suitcase. You called 911? Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
Very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with pigs in my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to it.
Objection, Judge, will you strike? This is outside the motion to suppress. They're not making any allegations that were stated as involuntary, mental state, or state of consequence.
Response?
Judge, we're talking about, I'm just getting some preliminary information. Her interrogation is the next day.
The state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the day before the interrogation.
I understand that.
We're not talking about
But are
intoxication.
you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it. Objection sustained and stricken.
Did you speak to the deputy about what had happened?
Yes.
Okay. And then, were you asked to stay on scene?
By those, yes. By those detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically that it was not quickly.
Okay. Did detectives, the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? Was the phone issue before the car?
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hoopsall asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hoopsall.
How did you unlock it?
She handed it to me. I unlocked it.
How do you unlock your phone?
It was with a passcode.
And when you unlocked it, did you give it back to the detective?
I did.
Did you ever see the phone again? After that incident, was the next time you were spoken to by Detective Coatsel was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective went to her.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
She was just going to be asking me general questions.
Was there ever any mention about normal protocol? Okay. What about once you got in the squad car?
Don't in the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights? All right. Did you answer the questions?
Yep.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you reported on your phone from the night before? Were you ever questioned about those videos at the scene?
I was not.
Like after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene?
Sí.
I was instructed by those to not.
Jugó con una, Pepo
And
jugó
how
con una
long did you stay
perrita
on the scene?
pitbull de 6 meses, hermosa.
¿Una blanca o no?
Sí.
How long,
Tiene que ser la
how long
perra
did it
que
take
lo-
before the investigation was
La que yo
completed?
te decía que la agarraba y hacía lo que quería ver.
No, no, esta era cachorra,
At some
tiraba
point,
mucho al
did they
piso.
leave? And at some point, did they tell you they were finished with the work there at the scene?
Claro, la que yo te digo
What did you do?
lo entierró entero.
Ah, no, esta se le tiraba porque le tenía un poco de miedo.
To my former husband's residence when I was
All right, and how far was that away? How did you get there? What was the reason that you wanted to stay over there the night?
No, pero lo bueno es que está socializando de nuevo.
Y no, con hembras siempre.
Sí.
Now,
No, pero por lo menos.
later that evening,
Sí,
you were going to spend the night
Pero
with
no
your
te
son
nadie más.
and with your ex-husband?
con él.
And did you do that?
my son was.
Later that evening, did you attempt to contact Detective Coatsel?
Pobrecito.
And whose phone did you use?
Le conté a los dueños de la perrita
You
esa
said
lo
your
que
phone had
pasó,
been
no me
seized?
podían creer. como digo.
And you had consented to that? You signed a
Le
form?
conté a los dueños de la
to
perrita.
take the phone? Have there been any discussion about returning the phone?
She returned back to my apartment to return my phone.
And when did they tell you this?
Before they left the scene.
And did they tell you they would return your phone where?
No da la cara, no pone la cara. Sí.
And is that what you understood they were going to do?
Pata,
Was there ever any talk about you coming to the sheriff's department that the day of this event?
pata, pata, pata.
All right, so later that evening, you borrowed your ex-husband John Boone's phone and made a phone call. How did you know Detective Coatsel's private cell number?
Bien, amigo.
And did you call her?
Muñoz.
And that would have been on February the 24th of 2020? All right, can you tell us why you were calling her that night?
Before she left, giving me her personal cell phone number, she told me if I were.
Yo sé que el pequeño anda como que me pesca harto a mí.
I just wanted to talk to her about something that was the case for me to talk.
¿Qué pasa? Mira, es hermoso estás.
And
Es hermoso.
very uneasy about
Todo
how
despeluchado.
they left it.
Sustained.
Se pica,
Go ahead.
mi amor.
There's no pending motion at this time.
Okay, you were concerned about the case and you wanted to call her? And did you talk to her?
Yes.
What did you say to her?
I told her, in all honesty, that I felt that she
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Hice un relleno para hacer empanadas, pero no
You
compré
may
las
answer the question
tapas.
back.
Hice un relleno para hacer empanadas, pero no compré las tapas.
¿Y lo habría cubierto o no?
No creo.
No creo.
Pasado mañana.
Did y'all have a discussion about your phone?
Yeah.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me
Oye, se ve así.
and
Sí.
just
Hay que tratar de no tentarse y no comérselo antes. Hay que tratar de no tentarse y no comérselo antes de tiempo.
Was there any
Que hay que no
discussion
comérselo
about
antes
you
de
being
tiempo.
interrogated
Ah,
at the
sí.
sheriff's department?
No, es que sí que les hace
Is your
como que
understanding
sí.
the sole purpose of you
No,
going to
no.
the sheriff's
Ah,
department
no.
upstairs to pick up your phone? And the sole reason for the change in plans from them bringing the phone to you is because Detective Cupsall was pregnant, not feeling well. So the next afternoon, did you drive to the sheriff's department? Tell us, when you parked your car, where you went, what happened?
I parked my car and left it in my car and walked through the front door and went to the window asking who I needed to see, and they eventually came upstairs and Detective Malone came downstairs. And I thought I was supposed to be picking my phone up over at a particular window. And he says, no, your phone is upstairs. So we just went upstairs. And that's where you can put my phone.
All right, and so did he escort you upstairs?
Did.
How did y'all get upstairs?
In an elevator.
And was he, what was he wearing? His firearm was on his waist? Okay. So y'all got off the elevator, where did you go from there? So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room? So directly off the elevator, and walked into the interrogation room. And then we've got the video on there. Now, you not watched the video, correct? And you've seen the motion where I've referred to the question where she asked you to sit down.
Yeah.
You recall that happening? Did that refresh your memory watching the video? Do you recall her saying that she had received the autopsy?
Yeah.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy? This was prior to you being read your Miranda rights. She also said, we're not done talking about the incident. You recall that? And then she said, we just have to do it. How did that make you feel?
Sustained.
Were you trying to comply with the officer's demand? Were you trying to cooperate? Were you polite with him? And when she said that, we just have to do it, you said just like we did yesterday. And then you said normal protocol. Is that what she had said the day before? Normal protocol. Had she said the same word? You said normal protocol. To her. So she read the Miranda rights to you, except number 9. She read the rights, and then she said, do you understand what I've just read to you? And you agreed that you had. But you were not read, having these rights in mind, you agreed to speak to me now.
Qué pesado, parece.
Is it fair to say that after she read the Miranda rights, and after she said, do you understand the rights that I've just read to you, that she read right into the question? So she never got the answer from you. Do you agree to speak to us now? The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody.
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
But she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well, under the circumstances, it would matter when she didn't feel she was free to leave. She was in an enclosed small space. She was
That all goes to whether or not...
She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with it? Those are all factors that, under Ramirez, as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or whether it happens outside a police station. So just that environment alone,
That goes to whether or not it was a custodial interrogation. That I'm struggling with the connection on that being non-compliance with Miranda, coercion, or the third ground of voluntariness.
well, I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
Subjectivity matter.
excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's right.
Objection's overruled. I'm sorry, the objection's sustained. I apologize.
Did you understand you were not going to get your phone back until you answered the questions?
Sustained.
Did you have some questions for them at the end? Did you feel like you had a choice in answering their questions?
Sustained.
And that
Para,
day,
Tito.
you came to the sheriff's department to get your phone? Did you know that you were going to be placed in custody? Did you know that you were going to be arrested? Did you know that you were going to be questioned? Were you trying to cooperate with law enforcement based on her statements that you have to talk to us? Were you there answering the questions because she confirmed that this was normal protocol? That's all the question.
Any cross-examination?
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct? You were impaired by alcohol, correct?
Just that, yeah.
Okay. And that was consumption from the night before, correct? So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Coatsville that afternoon?
One more time.
Did the alcohol have any effect on your memory of what happened between you and Detective Coatsville that afternoon? Then?
Did alcohol affect the conversation?
There's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you testified to today that you said happened on that afternoon of February 24th, 2020? So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Had alcohol under the influence or impaired?
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection? What are the legal grounds of your objection? You may proceed.
And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years? Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
I would object to that. I'm not understanding the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she's testified to today, that particularly the things in conflict with Detective Coatsville's testimony, and the court, of course, in a motion to suppress, has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out, so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response. Anything further? Mr. J.
I'm not specifically asking her what she said that was different, and obviously if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020? And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I,
And so you understand the benefit of this motion to suppress being granted? No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger? Okay. Anything else from the state other than argument?
Just argument.
Okay, all right. Once Ms. Boone sees we can proceed with any argument, and as the court identified previously, I have reviewed all y'all's authorities that were provided. Mr. Owens, it's your motion, sir. You may proceed.
Which my understanding of the law regarding Miranda, first issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions.
¿Sabes cuánta carne tiene esta delicia de hamburguesa? 0% carne, 100% sabor y por la semana baby de mostaza un 40% de descuento. Vamos, 0% carne, 100% sabor, 40% solo mostaza. Solo es
Go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, it can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you've got Detective Kopsel on the one hand. I got to read you your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal. To tell a suspect, we have to talk to you. We just have to. Before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It takes the Miranda that comes before it. We're a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses. A traumatic event, she lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper, it's illegal, it's coercive. It forces this not to be a valid waiver of her rights under that circumstance.
Ahora sí.
Coupled with the fact that she came down under false pretenses. Coupled with the fact she doesn't have an honest question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I just read to you? I'm paraphrasing. But then Detective Kopsel goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah. To be given that opportunity. But the way I understand, Detective Kopsel had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use. Which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
The United States Supreme Court has said that confessions are good. They're good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th, they are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less